Imagine spending like 3 years and over $1 million prepping for the biggest trial of your entire life.
Oh, yeah. A total nightmare scenario.
Right. You've got expert witnesses. You've prepped this amazing opening statement. You have literally boxes of evidence ready to wheel in.
Yeah.
And then a week before you stand in front of the jury, you find out your entire case was just killed by a single piece of paper from a clerk.
Just wiped out.
You don't get the opening night.
Yeah.
No dramatic cross-examination. The trial is just, well, it's over.
You know, it's a shocking reality for a lot of people entering the legal system because, I mean, we have this culturally ingrained expectation of the grand trial, right?
Like in the movies.
Exactly. The big climax where everything is decided in front of 12 peers. But if you actually look at the day-to-day reality of the American legal system, specifically federal courts, the vast, vast majority of civil cases never see a jury.
They just get resolved backstage.
Yeah, they never make it to the stage at all.
And the mechanics of how that happens, how a case just disappears before the curtain goes up, that is exactly our mission for this deep dive.
It's a huge topic.
It is. We're taking a magnifying glass to the federal rules of civil procedure. We want to master this concept of adjudication without trial.
Which is crucial.
And I know we have a lot of listeners right now who are, deep in the trenches, studying for the multi-state bar examination. The MBE.
Oh, the MBE. Yeah, that's a beast.
It really is. You're staring down this massive test, and the text you have to read is just incredibly dense.
Well, it's like reading ancient legal poetry sometimes.
Right. It's filled with formal phrasing that doesn't sound like, how actual human beings speak.
Yeah.
And for our listeners where English is a second language, it's even harder.
Oh, absolutely. And the bar examiners, they design their questions around those dense phrases.
They lay traps, right?
Yeah, totally.
Oh.
They build traps based on tiny procedural details, highly specific timelines. So if you try to just memorize the text of the rules mechanically, the volume of info just crushes you.
It's too much.
You really have to understand the underlying logic. Like, why do these off-ramps even exist in a lawsuit?
So that's what we're going to do. We're going to strip away the confusing jargon. We're going to translate the formal language into everyday, simple English.
I love it.
Because, we want to build a logical path through these rules. We'll look at what happens when a plaintiff just wants to quit, what happens when a defendant completely ignores the lawsuit, and what happens when both sides are totally ready to fight, but the judge says, no, this fight is an illusion.
Right.
So let's jump into that first scenario.
Yeah.
The plaintiff wants out.
Okay, yeah. Rule 41.
Specifically, Rule 41A, voluntary dismissals. And the best way I can visualize this is it's like taking your chips off the poker table before the dealer even finishes dealing the cards.
That's a really good way to think about it. You sat down, you bought in, but for whatever reason, you changed your mind and you want to walk away.
Yeah.
And if we take that poker analogy further, maybe the plaintiff realizes their hand is just incredibly weak.
Or they ran out of money for lawyers.
Exactly. Or, maybe they realize they filed in a federal court in New York, but they actually want to sue in a state court in California.
So they just want to voluntarily dismiss their own case.
Right. But, you can't always just grab your chips and run at any moment without consequence. Timing is literally everything here.
Because if the other players already placed their bets, like if the defendant already spent 10 grand hiring a defense firm to read the complaint, it doesn't seem fair to let the plaintiff just vanish.
It wouldn't be fair at all.
So what's the exact timeline? Like, when can a plaintiff walk away without having to beg the judge for permission?
Okay, so under Rule 41, a 1A, a plaintiff has an absolute right to dismiss their action without leave of the court.
Meaning without asking the judge.
Right, without asking the judge. But only if they do it early enough. Specifically, they have to file a notice of dismissal any time before the opposing party serves an answer or a motion for summary judgment.
Okay, before an answer or a motion for summary judgment.
Yeah.
What if the defendant just filed a motion to dismiss, like a Rule 12b-6 saying the complaint is legally flawed? Does that stop the plaintiff from walking away?
It actually does not.
Wait, really?
Really. A motion to dismiss is not an answer, and it's not a motion for summary judgment.
Oh, that sounds like a massive MBE trap.
It is heavily tested. The examiners love that one. The logic is all about the investment of resources.
How so?
Well, drafting an answer means you have to meticulously admit or deny every single factual allegation in a complaint. And drafting a motion for summary judgment means compiling actual evidence.
Which is super expensive and time-consuming.
Exactly. It's a massive undertaking. So if the defendant hasn't put in that specific type of hard work yet, the court lets the plaintiff just pack up and leave.
That makes sense. But what if that deadline has passed?
Like they already filed the answer.
Yeah, what if the answer is served, but then both the plaintiff and the defendant are like, wow, this lawsuit is a terrible idea. Can they both just make it go away?
Oh, absolutely. The rules completely accommodate that. If the timeline passed, the plaintiff can still voluntarily dismiss without the judge's permission if all the parties sign a document agreeing to it.
Okay.
It's called a stipulation of dismissal.
So it's basically a mutual peace treaty.
That's exactly what it is.
Okay, so the plaintiff packs up and leaves, either by filing the notice early or getting everyone to sign the peace treaty. The rule states this voluntary dismissal is without prejudice.
Yes.
That's one of those super formal phrases. For the ESL listeners, let's translate without prejudice into practical terms.
Sure. Without prejudice basically means no harm done, you get a do-over.
A do-over, I like that.
Yeah, the court is explicitly saying, hey, we're not judging the underlying facts of your dispute here.
So I can just file the exact same lawsuit again later.
Exactly. You are free to take your lawsuit, fix whatever was wrong with it, and file it again in the future as if the first attempt never even happened. The only thing you have to worry about is the statute of limitations. As long as you're within your time limit to sue, there's no permanent penalty.
But wait, if I can just file a lawsuit, dismiss it without prejudice, and then file it again? What stops someone from weaponizing that?
What do you mean?
Like, let's say I'm a massive corporation and I want to bleed a small business dry.
Okay.
I sue them, they hire a lawyer and panic. Then, right before they file an answer, I dismiss the case.
Right.
Then 2 months later, I sue them again, they panic, hire a lawyer again. I dismiss it again. I mean, I could just bankrupt them with legal anxiety without ever actually fighting the case.
Yeah, and that mechanism of abuse is exactly what the drafters of the rules anticipated.
Oh, so there's rule against that.
Oh, yeah. They needed a circuit breaker to stop endless harassment. And this brings us to one of the most critical, highly tested traps in all of civil procedure.
Okay, MBE takers, listen up.
It's the two-dismissal rule.
The two-dismissal rule. Let's map out how this circuit breaker works.
It is very rigid. The rule says if a plaintiff voluntarily dismissed a prior state or federal action based on the same claim,
Okay.
and then they file it again, and then voluntarily dismiss it a second time by filing a notice, that second dismissal is automatically with prejudice.
With prejudice.
Yeah.
Meaning the permanent opposite of what we just talked about.
Yes. With prejudice means you are permanently blocked.
Wow.
It operates as what we call an adjudication on the merits. You can never, ever file this claim against this defendant again. The court treats that second dismissal as a final judgment against you. Your claim is dead.
Okay, let's trace a concrete timeline just to make sure this is locked in perfectly.
Let's do it.
Let's say I'm a software developer. I sue a tech giant in state court for stealing my code.
Okay.
A week goes by. I realize my paperwork is messy. But before the tech giant files an answer, I file a notice of voluntary dismissal.
Right. That first one is without prejudice. You're safe. You can sue them again. You just used your one free pass.
Okay, cool. So a month later, my paperwork is fixed, but this time I decide I want to sue them in federal court.
Okay. Different court system.
Yeah. I file the exact same claim for stealing my code, but then I get cold feet again. Maybe I lost my star witness.
Uh-oh.
So before they file an answer in federal court, I file another notice of voluntary dismissal. I'm safe, right? Because I'm in a different court system, and I did it before the answer.
The trap snaps shut.
Oh, no.
It does not matter that your first lawsuit was in state court and your second was in federal, because you already dismissed the exact same claim once before anywhere in the country.
The second one is dead.
Yes. The second notice automatically operates as an adjudication on the merits, with prejudice. You can never sue that tech giant for stealing that code again.
That is brutal.
It really is. And examiners will constantly give you a fact pattern where a plaintiff dismisses a state case, then dismisses a federal case, and then tries to file a third time.
And the third filing just gets thrown out immediately.
Exactly. You have to spot that.
Okay, so that's what happens if the plaintiff leaves early. And we know the two-dismissal trap. But what if the plaintiff just waits too long?
Meaning the defendant already answered.
Yeah. The defendant filed an answer, and they refused to sign a mutual peace treaty. Can the plaintiff still voluntarily dismiss?
They can try, but the unilateral power is totally gone. Now we're looking at Rule 41-2.
Okay.
Once that deadline passes, the action can only be dismissed by a court order. The plaintiff formally has to ask the judge, and it is completely up to the judge's discretion to say yes or no.
So the plaintiff essentially has to plead their case just to be allowed to quit. Like, please, Your Honor, can I drop my lawsuit?
Exactly. And the judge is going to look at the entire landscape, like how much time has passed, how much money did the defendant spend on discovery, did the defendant file counterclaims?
Right.
Now, a voluntary dismissal by court order is usually without prejudice unless the judge says otherwise, but the judge has the power to attach terms and conditions to protect the defendant.
What kind of conditions?
Usually money. The judge might say, yes, you can dismiss without prejudice, but because you dragged the defendant through 6 months of expensive litigation, you have to pay their attorney fees.
Ouch.
Yeah.
Mm-hmm.
Or the judge might just deny the request entirely if dismissing the case would cause clear legal prejudice to the defendant. It's totally a matter of judicial discretion now.
That makes perfect sense.
Mm-hmm.
Before we wrap up this voluntary part, does this only apply to the person who started the lawsuit? Like, what if the defendant fired back with their own claims?
The rules maintain total symmetry here.
Okay.
Rule 41C explicitly states that these exact same rules apply to counterclaims, cross-claims, or third-party claims.
Good to know.
Yeah, the person bringing the claim, whether they're the original plaintiff or a defendant firing back, they just have to dismiss it before responsive pleading is served. The mechanics are identical.
Okay, let's do a really quick, simple recap for our ESL listeners studying for the MBE.
Perfect.
So, a plaintiff wants to walk away.
Right.
Voluntary dismissal. If they do it early enough, before an answer or a summary judgment motion, they get out clean, without prejudice.
Yes.
But if they pull that ripcord twice on the same claim, the two-dismissal rule kicks in and permanently kills their case.
With prejudice. Exactly.
And if they wait too long and the defendant already answered, they have to beg the judge, and the judge might make them pay for the privilege of quitting.
You nailed it.
Awesome. So that's the plaintiff choosing to back out. But what if the plaintiff doesn't want to leave? They're just being super lazy?
Yes.
Like they file the lawsuit and then just refuse to play by the rules. What happens then?
This is when the court takes control of its own docket. This is involuntary dismissal under Rule 31B.
So involuntary dismissal is like the judge throwing a red card and ejecting the plaintiff from the game.
It is the ultimate sanction. If a plaintiff initiates a lawsuit but then fails to prosecute the case, or if they disobey the rules or a direct court order, the defendant can file a motion asking the court to involuntarily dismiss the action.
Let's translate failure to prosecute. Because, I mean, that sounds like a criminal law term, right?
Yeah.
But we're in civil court.
Yeah, in a civil context, failure to prosecute just means you started the machinery of a lawsuit, but you refuse to do the actual work to move it forward.
Like not showing up.
Exactly. You aren't showing up to scheduled hearings. You aren't filing your mandatory disclosure paperwork. You're just letting the case sit dormant on the judge's desk for months.
And judges hate that.
Oh, they despise it. The federal court system is incredibly congested. Judges will not tolerate a plaintiff who hoards their limited resources by filing a case and then just abandoning their responsibilities.
So the judge brings down the hammer and kicks him out.
Yep.
Now, here is the critical question for the bar exam. When a judge involuntarily dismisses a case for breaking the rules, is it without prejudice, where the plaintiff can just fix their lazy behavior and try again? Or is it permanent?
This is the dividing line you have to memorize. Unless the judge's order specifically states otherwise, an involuntary dismissal is with prejudice. Yes. It operates as an adjudication on the merits.
There's that phrase again. Adjudication on the merits. Let's unpack the weight of those words again.
Sure. Think of the merits as the actual substantive truth of the dispute. Who broke the contract? Who was negligent in the crash?
Right.
When a dismissal is an adjudication on the merits, the legal system is applying a massive legal fiction. It treats the situation exactly as if a full trial had taken place, all witnesses testified, the jury deliberated, and the plaintiff definitively lost.
So even though no one ever looked at a single piece of evidence, the law just pretends a full trial happened and the plaintiff lost.
Exactly. They are permanently barred from bringing this case again. It triggers claim preclusion or res judicata. The claim is dead forever.
But wait, are there exceptions?
Yes. And this is where you need to pay very close attention. The rule carves out 3 very specific exceptions to this harsh penalty.
Okay, what are they? When did the plaintiff get kicked out but not permanently banned?
The rule strictly outlines 3 situations. Number 1, a dismissal for lack of jurisdiction. Number 2, improper venue. And number 3, failure to join an indispensable party under Rule 19.
Okay.
If the case is dismissed for any of those 3 reasons, it is without prejudice.
Let's explore the rationale here,
Yeah.
because, memorizing a list of 3 random things is hard,
Yeah.
but understanding why they're on the list makes it stick forever.
Definitely.
Why do these 3 procedural failures escape the permanent death penalty?
It all comes down to the fundamental authority of the court.
Okay.
Let's look at the first one. Lack of jurisdiction. Jurisdiction is the court's constitutional power to even hear a specific type of case.
Right.
If a federal judge looks at a lawsuit and realizes, wait, there's no federal question here and these parties are from the same state, so there's no diversity jurisdiction, the judge must dismiss the case.
Because they don't have the power.
Exactly. The judge is literally saying, I do not have the legal authority to evaluate the facts of your dispute.
So if the judge never had the power to look at the facts in the first place, it would be a massive overreach to pretend they made a final, binding decision on those facts.
Precisely. You cannot have an adjudication on the merits if you never had the power to reach the merits.
That makes total sense.
And the identical logic applies to the second exception, improper venue.
I mean, use just about location. Right.
Purely geographic convenience and statutory courthouse locations. If a judge dismisses a case because it was filed in New York when it legally belonged in California, the judge isn't saying the underlying claim is garbage.
The judge is just saying, you brought this to the wrong building.
Right. So the penalty is just the inconvenience of flying to California and filing it in the right building. The claim itself survives.
Okay, and the third exception, failure to join an indispensable party under Rule 19.
This means there is a person or an entity out there who is so deeply tied to the dispute that it would be fundamentally unfair to hold a trial without them.
Like who?
Imagine 2 people arguing over who owns a piece of property, but they completely left out the bank that holds the primary mortgage.
Oh, yeah.
Yeah.
You can't resolve that without the bank.
Exactly. So the court dismisses the case, but again, the court hasn't decided who actually owns the property. They just identified that a crucial player was missing from the table.
So in all 3 of these, jurisdiction, venue, and missing an indispensable party, the dismissal is without prejudice.
Yes. The plaintiff can fix the structural error and try again.
Okay, before we move to the defendant's side, I just want to make sure I have this whole structural timeline locked in.
Go for it.
So, mini recap number 1. If I'm the plaintiff, I can voluntarily walk away clean before the answer.
Yep.
But if I do it twice, I'm dead in the water.
The two-dismissal rule.
Right. If I wait too long, I have to beg the judge to leave.
Yes.
And if I just stop showing up or I break the rules, the judge hits me with an involuntary dismissal on the merits with prejudice, unless my error was about jurisdiction, venue, or forgetting a key person.
You have the structural mechanics perfectly aligned. And trust me, the examiners will relentlessly test those 3 exceptions.
Oh, I bet.
They'll give you a scenario where a case is dismissed for improper venue, the plaintiff correctly refiles in the right venue, and the defendant argues it's barred by res judicata because it was already thrown out once.
And the student has to know instantly that the defendant is wrong.
Exactly. Venue dismissals are never on the merits.
Awesome. Okay, let's pivot the camera entirely.
Yeah.
We spent all this time looking at what happens when the plaintiff messes up or gives up.
Right.
But what if the plaintiff is a model citizen? They draft a flawless complaint, they serve the summons properly, they file everything perfectly on time.
Jack?
But the defendant just completely ignores the lawsuit. They bury their head in the sand.
This brings us to defaults and default judgments,
Right.
Rules 12, 55, and 60.
So what happens when you ignore a federal lawsuit?
When a person or a corporation is officially sued, the clock starts ticking the very second they are served. They cannot just ignore the paperwork and hope it magically goes away.
How fast is that clock ticking? What's the absolute deadline for the defendant to act?
Under Rule 12, a defendant has exactly 21 days from the moment they are officially served to file a response.
21 days. Not a month, not 30 days.
Yeah.
Exactly 21.
Yes. And that response has to be substantive. They have to either file an answer, going line by line, admitting or denying the allegations, or they must file a pre-answer motion, like a Rule 12b motion to dismiss.
Okay, so they have to do real legal work.
Right. They can ask the court for an extension of time, sure, but if day 22 arrives and the defendant has done absolutely nothing, they have triggered the default process under Rule 55.
Now, here is where so many people get confused, and it's a massive trap.
Oh, a huge trap.
I think the common assumption is
Yeah.
that on day 22, if the defendant hasn't answered, the plaintiff just strolls into the courtroom, the judge bangs the gavel, hands them a giant bag of money, and the case is over.
Right.
Is it really that instantaneous?
That is the #1 misconception. And if you assume that on a test, you will lose points.
So it's not an automatic win.
A default is absolutely not an automatic, instantaneous win where you just walk out with a check. The federal rules require a strict two-step process.
2 steps. Okay.
You have to understand the severe distinction between an entry of default and a default judgment.
Okay, let's separate them entirely. Step 1, entry of default. What is actually happening here?
An entry of default is purely an administrative act. It just records the historical fact that the defendant failed to respond within the 21-day window.
So who does the plaintiff talk to? The judge?
No, not the judge. The plaintiff goes to the clerk of the court and submits an affidavit. The plaintiff essentially says, look, here's the proof. I served the defendant on the 1st of the month. It is now the 25th. They haven't filed anything.
And the clerk just checks the calendar.
Exactly. The clerk reviews the dates, agrees, and enters the default onto the official court docket.
But if it's just an administrative note by a clerk, what does that actually achieve for the plaintiff? Like, why even bother?
Because it cuts off the defendant's right to participate in the case.
Yeah.
An entry of default is like locking the doors to the stadium. The opposing team didn't show up for the kickoff, so the referees lock the gates. Even if the defendant suddenly wakes up on day 26 and tries to file an answer, the clerk will reject it. They are locked out.
That's a great analogy.
But locking the stadium doors doesn't mean you've been handed the championship trophy. It just means the other team can't mount a defense right now.
Okay, that clarifies so much. Step 1, entry of default, just locks the stadium doors. But you still don't have the money.
Right.
Which brings us to step 2, default judgment. This is the actual trophy.
Exactly. A default judgment is the final official legal order that creates a binding financial obligation for the defendant. It is a fully enforceable judgment. It carries the exact same weight as a judgment issued after a grueling 6-week jury trial.
Wow.
But the critical nuance here is who actually issues that judgment. It depends entirely on the type of damages the plaintiff is demanding.
How does the type of money change the process?
The rules draw a hard line between a sum certain and damages that are not certain.
Okay, let's look at a sum certain first.
Sure. Suppose you're suing a business partner for breaching a specific promissory note. The note plainly states they owe you exactly $50,000.
Okay, so there's no debate about the math.
Right, there's no debate. It is a sum certain. In that specific scenario, after the clerk enters the default in step 1, the plaintiff can immediately request the default judgment from the clerk.
The clerk can issue it.
Yes. The clerk has the authority to issue the final judgment for $50,000. The judge doesn't even need to be in the building.
Because it's just administrative calculator work. There's no subjective decision to make.
Exactly.
But what if the lawsuit is about a catastrophic car crash? Like the plaintiff alleges the defendant ran a red light, caused permanent back injuries, and the plaintiff wants damages for pain, suffering, and future medical care.
Well, you cannot calculate the exact dollar value of human pain and suffering on a calculator.
Right.
So that is not a sum certain. When the amount of damage is uncertain, the clerk has zero authority to enter a judgment.
So they have to go to the judge now.
The plaintiff must apply directly to the court, meaning the judge. And the judge cannot just take the plaintiff's word for it. They're not going to just say, oh, you want $5 million. Here you go.
What does the judge do?
The judge will typically hold a special evidentiary hearing, often called a prove-up hearing. The judge will review medical records, listen to expert testimony about future lost wages, and make a judicial determination of what a fair dollar amount actually is before officially issuing the default judgment.
So the timeline for defaults goes like this. 21 days pass.
Right.
Step 1, plaintiff goes to the clerk to get the entry of default to lock the stadium doors.
Yes.
Step 2, plaintiff seeks the default judgment to actually get the money. If it's exact math, the clerk handles it. If it requires subjective evaluation, the judge handles it.
Perfect summary.
Okay, but what if the defendant finally realizes what's happening? Let's say it's day 30. They find the summons buried under a stack of mail in the office, and they rush to the courthouse in an absolute panic.
Oh, boy.
Is it too late? Can they unlock the stadium doors?
They can try, but the legal standard they have to meet depends entirely on how far the plaintiff has advanced through that two-step process.
So it's highly structured again.
Very. If the plaintiff has only secured the entry of default, meaning they locked the doors but haven't gotten the actual judgment yet, the court can set aside that entry for good cause under Rule 55C.
Good cause. That sounds kind of flexible. How do judges interpret that in reality?
It is relatively flexible. You have to remember, judges strongly prefer to decide cases on their actual merits rather than through procedural technicalities.
Makes sense.
So when evaluating good cause, the court asks a few practical questions. Is the defendant acting in good faith? Do they actually have a potentially winning defense, or are they just trying to delay the inevitable?
And what's their excuse, probably?
Exactly. What was the reason for the delay? For example, if the defendant proves the summons was delivered to their corporate mailroom, but the mailroom literally flooded and the paperwork was destroyed before it reached the legal department.
That's beyond their control.
Right. A judge will almost certainly find good cause, unlock the doors, set aside the entry of default, and let the lawsuit proceed.
Okay, so undoing step 1 is achievable if you have a legitimate, honest excuse.
Yes.
But what if the plaintiff moved fast and they already completed step 2? The official default judgment has already been signed and entered onto the docket.
If the final default judgment has been entered, the defendant is facing a massive uphill battle. You can no longer rely on that flexible good cause standard.
This is the new standard.
You must meet the incredibly strict requirements of Rule 60B, which governs relief from a final judgment.
Why does the standard suddenly become so much harsher just because the judgment was signed?
Because of a core philosophy of the legal system, the finality of judgments.
Finality.
Yeah, a judgment is the ultimate resolution of a conflict. When a court issues a final judgment, the winning party needs to be able to rely on it. They need to be able to take that judgment to a bank, freeze the defendant's assets, and start collecting their money.
That makes total sense.
If defendants could easily undo final judgments just by showing up late with a decent excuse, the entire system of enforcement would collapse into chaos.
No one would ever pay.
Right. Therefore, Rule 60B requires showing severe, extraordinary circumstances to overturn a judgment.
Like what?
You have to prove things like excusable neglect, newly discovered evidence that couldn't have been found earlier, or outright fraud by the opposing party. It is incredibly difficult to achieve.
So the takeaway for any defendant and anyone taking the MPE is do not ignore the clock.
Never.
If you miss the 21 days, you might fix an entry of default with a good excuse.
Yeah.
But if you let it get all the way to a final default judgment, you are locked in a steel cage trying to fight your way out under Rule 60B.
Exactly.
I'll do another quick mini recap for our ESL students.
Good idea.
Default process. 21 days to respond.
Yeah.
2 steps. Entry of default, which stops the descendant from responding.
Okay.
And default judgment, which actually awards the money.
Right.
Clerk handles exact numbers. Judge handles uncertain numbers.
Yes.
And it is way easier to undo an entry of default with good cause than a final default judgment under Rule 60B.
Spot on. That's all the key MB material for defaults.
Perfect. So let's transition to the next major phase of our deep dive.
Okay.
We started with dismissals, which happen when the plaintiff essentially gives up and wants to leave. Then we discussed defaults, which happen when the defendant refuses to show up.
Right. In both scenarios, someone effectively forfeited the game early.
But what is the off-ramp when neither side forfeits? What happens when both sides are armed to the teeth, they've hired expensive law firms, they've taken depositions, they're completely ready to go to trial. But the judge looks at all the evidence and realizes the fight itself is an illusion.
Then we arrive at one of the most powerful, frequently utilized, and heavily tested rules in all of civil procedure. Rule 56, summary judgment.
Summary judgment. This is like the holy grail for a defense attorney, right?
Oh, absolutely.
Winning the entire case and shutting it down without having to endure the unpredictable risk and massive expense of putting a jury in the box.
It's the dream.
What is the core legal standard here? What exactly must a judge see to grant a motion for summary judgment?
The standard is codified in Rule 56A. A judge shall grant summary judgment if the moving party shows 2 things. First, that there is no genuine dispute as to any material fact, and second, that the movant is entitled to judgment as a matter of law.
No genuine dispute as to any material fact. Okay, that phrase is the beating heart of civil litigation. But again, it sounds like formal legal poetry.
It really does.
Let's break those words down into functional concepts for our ESL listeners. What makes a fact material?
A material fact is a fact that actually dictates the outcome of the legal claim under the substantive law. It is a fact that matters.
Use an example.
Imagine a lawsuit over a car crash in an intersection. The plaintiff claims the defendant ran a red light. The defendant claims the light was green. The color of that traffic light is a material fact. Whoever is right about the light wins the case.
Because it proves negligence.
Exactly.
Yeah.
Now, conversely, imagine the plaintiff testifies that the defendant was wearing a bright yellow shirt, and the defendant swears he was wearing a blue shirt.
Okay, they're arguing about the shirt color.
That is a factual dispute, but it is not a material fact. Because the color of the driver's shirt has absolutely no bearing on who was negligent in the crash. The judge does not care about the shirt.
Okay, so the dispute has to be over something that legally matters. Now, what makes the dispute genuine?
A dispute is genuine if there's enough conflicting evidence that a real jury needs to step in and resolve it.
Okay.
The landmark Supreme Court case on this exact standard is Anderson v. Liberty Lobby. The court established that a genuine dispute exists only when a reasonable jury could look at the competing evidence and potentially return a verdict in favor of the non-moving party.
So if it's completely one-sided.
Right. If a judge looks at the entire mountain of evidence and concludes that a reasonable jury could only possibly pick one winner, that it's entirely one-sided, then the dispute isn't genuine, it's manufactured.
So, boiling that down, summary judgment means there is literally nothing important left for a jury to do.
Exactly.
Because the fundamental constitutional purpose of a jury is to listen to two conflicting stories, weigh the credibility of the witnesses, and decide who is telling the truth.
Right.
If there are no conflicting stories that matter, or if the evidence is so lopsided that only one conclusion is rational, sending the case to a jury is just a massive waste of judicial resources.
It's a huge waste. The judge can just apply the law to the obvious facts and declare the winner.
That makes total sense.
But because the court is taking the extreme step of depriving a citizen of their Seventh Amendment right to a jury trial, the judge is bound by strict instructions on how to evaluate the evidence at this pre-trial stage.
What are the instructions?
The judge is not allowed to weigh credibility. The judge must view all the evidence and draw all reasonable inferences in the light most favorable to the non-moving party.
In the light most favorable.
Yeah.
So if I am the person fighting against the summary judgment, the non-moving party, I get the absolute benefit of the doubt.
You do. Let's return to the car crash. The defendant files a motion for summary judgment, arguing they had the green light.
Okay.
The defendant submits sworn affidavits from 3 bystanders, a priest, and a police officer who all swear the defendant's light was green.
That's a lot of credible witnesses.
It is. Now, the plaintiff submits one single affidavit from a bystander who says, "It was raining really hard and I wasn't wearing my glasses, but I'm pretty sure the defendant's light was red."
Wow, that is a terrible witness.
Right. If a judge were weighing credibility, they would obviously side with the defendant. But at the summary judgment stage, the judge cannot do that. The judge must look at the plaintiff's weak, blurry witness and give them the benefit of the doubt.
Even against the priest and the cop.
Even against them. Because there is a tiny sliver of evidence that the light might have been red, a genuine dispute exists. The judge must deny the motion and say, "This is exactly what a jury is for. Let the jury decide who to believe."
That makes the hurdle for summary judgment incredibly high.
Very high.
Now, let's look at the mechanics of how the parties actually fight this battle in the paperwork. Who has the burden of proving what?
The process involves shifting burdens, and the defining Supreme Court case here is Celotex Corvi v. Catrit.
Celotex. Okay.
The process begins with the movement, the party asking the court to grant summary judgment. They carry the initial burden. They must point to the record and make a prima facie showing that there are no genuinely disputed material facts.
So they have to show the judge a clean slate. They present their deposition transcripts and documents saying, "Look at this record, Judge. The plaintiff has zero evidence that I did anything wrong."
Right. And Celotex established a critical nuance. If the movement is the defendant, they don't necessarily have to produce new evidence proving their innocence.
Oh, really?
No, they can simply point to the record and show that the plaintiff has completely failed to produce evidence for an essential element of the plaintiff's own case.
So they just point out the hole in the plaintiff's case.
Exactly. And once the movement does that, the burden violently shifts. The ball is now in the opposing party's court.
And what must the opposing party do to survive?
The opposing party cannot just sit back, cross their arms, and say, "I disagree, my complaint says you're guilty." They must affirmatively step up and set forth specific, concrete evidence showing that a genuine dispute of material fact truly exists.
They have to show the judge that there is dirt on that clean slate.
Exactly. They must produce affidavits, deposition testimony, or documents that create a conflict requiring a trial.
But wait, if all I have to do to survive summary judgment is create a factual conflict, what stops a desperate party from just lying?
That's a great question.
Because what if the defendant produces crystal clear evidence they had a green light, and the plaintiff, terrified of losing early, just signs a sworn affidavit saying, "No, the light was neon purple and a UFO was hovering over the intersection"?
Right.
Does the judge have to blindly give the plaintiff the benefit of the doubt and force a trial over a blatant lie?
No. And this exact dilemma reached the Supreme Court in a fascinating case called Scott v. Harris.
Okay, what happened in Scott v. Harris?
So the general rule is that judges cannot weigh credibility, right? But Scott v. Harris carved out a vital exception. The Supreme Court ruled that when opposing parties tell two completely different stories, but one of those stories is blatantly contradicted by the record so that no reasonable jury could ever believe it, a court should not adopt that fictional version of the facts.
Blatantly contradicted by the record. Give us the narrative of Scott v. Harris so we can visualize what that actually looks like in practice.
The case involved a high-speed police chase. The plaintiff, who was fleeing the police, was eventually rammed by a police cruiser, crashed, and was severely injured.
Okay.
The plaintiff sued the police officer for excessive force. To survive summary judgment, the plaintiff submitted sworn testimony claiming that he was in full control of his vehicle, he was stopping at red lights, he was using his turn signals, and he posed absolutely no threat to any pedestrians or other drivers.
Yeah.
According to his sworn story, the police rammed him for no justifiable reason.
And if the judge had to blindly accept the plaintiff's sworn testimony, there would be a genuine dispute and the case would go to a jury.
Exactly. But the police had something else in the record.
What do they have?
They had the dash cam video from the police cruiser.
Oh.
And the Supreme Court justices literally watched the tape. The video showed the exact opposite of the plaintiff's story.
The video clearly showed him driving crazy.
Yeah, the video clearly showed the plaintiff's car racing down narrow, two-lane roads in the dead of night, swerving into oncoming traffic, forcing cars off the road, and driving recklessly at terrifying speeds.
So the video completely obliterated the sworn testimony.
Exactly. Justice Scalia wrote the opinion and said, "We do not have to pretend the plaintiff's story might be true when we have undeniable objective video evidence proving it is a complete fiction."
That makes total sense.
No reasonable jury could watch that dashcam video and believe the plaintiff was driving safely. Therefore, the court refused to give the plaintiff the benefit of the doubt. They rejected the manufactured factual dispute and granted summary judgment for the police officer.
So Scott v. Harris serves as the ultimate shield against parties who try to invent fake factual disputes just to extort a settlement before trial.
It is a phenomenal shield. The court will give you the benefit of the doubt, but they refuse to throw out their own common sense when objective reality contradicts you.
That is a phenomenal story to anchor that concept.
It really is.
Now, let's dig into the practical plumbing of Rule 56. What kind of evidence are we actually talking about here? Because at the summary judgment stage, there's no courtroom, no jury box, and no live witnesses sitting on a stand. What is the judge actually reading?
The judge relies entirely on the written record generated during the discovery phase of the lawsuit. This includes written affidavits, transcripts of depositions, answers to formal interrogatories, admissions, and various documentary exhibits like contracts or emails.
Let's focus on affidavits for a moment, because this is where students consistently get tripped up.
Oh, yes. The hearsay trap.
Right. An affidavit is just a written statement that a person signs under oath. Now, in a normal live jury trial, if I want a witness to testify about a car crash, I have to bring them into the courtroom, put them on the witness stand, and let the opposing lawyer cross-examine them.
Yeah.
I can't just walk up to the jury and hand them a piece of paper the witness wrote at home. That is classic hearsay. The paper itself is out-of-court testimony offered to prove the truth of the matter asserted.
Exactly.
So, if an affidavit is technically inadmissible hearsay at a real trial, how can a federal judge rely on it to grant a summary judgment and end the whole case?
This is a highly nuanced distinction that you must grasp for the MBE. The rule, articulated beautifully in cases like the Seventh Circuit's Stinnett decision, is this. The physical format of the evidence at the summary judgment stage does not have to be admissible at a future trial, but the factual content contained inside that format must be admissible.
Let's expand on that. Format versus content.
Think of the affidavit as just a temporary delivery vehicle for the facts. The piece of paper itself, the format, would not be allowed into the jury room. But what the judge is evaluating is whether the witness who signed that paper could be called to the witness stand at the actual trial to testify to those exact same facts.
Okay, so the witness has to have personal knowledge.
Yes. For an affidavit to be used at summary judgment, it must be based on the witness's personal first-hand knowledge. It must affirmatively show that the affiant is competent to testify on the matter stated.
Let's test that with an example. If I submit an affidavit that says, "My neighbor Bob told me that he saw the defendant run the red light,"
the judge will strike that affidavit from the record and completely ignore it.
because Bob told me.
Right. Even if you called that witness to the stand at a live trial, they would not be allowed to testify about what Bob told them. That is hearsay within hearsay. The content itself is inadmissible, so the delivery vehicle is useless.
But if your affidavit says, I was standing on the corner of 5th and Main, and I saw with my own 2 eyes the defendant's car run through a solid red light.
Then the judge will accept that evidence for the purpose of summary judgment.
Why?
Because at a live trial, you could simply subpoena that person, put them on the stand, and they would be perfectly permitted to testify to their firsthand visual observation. The factual content is perfectly admissible.
That makes total sense. You were just giving the judge a preview of what the admissible trial testimony will be.
Exactly.
And Rule 56 explicitly states that a party opposing summary judgment cannot just point back to their original complaint. They can't say, Judge, look at paragraph 4 of my complaint where I alleged the light was red. That's my genuine dispute.
That is absolutely correct. Pleadings are just initial allegations. Once the Malfont pierces those pleadings with actual evidence, you cannot hide behind your initial claims. You must produce actual evidentiary facts showing a genuine dispute.
You have to put up or shut up.
Exactly.
Now, let's talk about the timeline. When in the life cycle of a lawsuit does this massive motion actually get filed?
Under Rule 56B, a party may file a motion for summary judgment at any time until 30 days after the close of all discovery.
Discovery being a grueling, months-long process where both sides are demanding documents, taking hours of depositions, and uncovering all the evidence.
Right.
So the logic is, you let all the dust settle, you let everyone gather their ammunition, and then you have a 30-day window to look at the battlefield and say to the judge, look at all this evidence. It's so overwhelmingly in my favor that a trial is unnecessary.
Precisely. And once that massive motion is filed, the opposing party generally has 21 days to scramble and file their response, pointing out all the factual disputes they believe still exist.
But what if one party tries to use this aggressively early? What if the defendant files a motion for summary judgment on day 10 of the lawsuit, before the plaintiff has even had a chance to subpoena a single witness?
That happens.
Can the plaintiff pause the process and say, wait, this isn't fair, I haven't been able to gather my evidence yet?
Yes, they can. The federal rules are heavily focused on equity. This scenario is protected by Rule 56.
Okay, how does Rule 56A work?
If the non-moving party can submit an affidavit showing the court specific reasons why they cannot present facts essential to justify their opposition at this exact moment, the court has broad tools.
Like what?
The judge can defer, considering the motion, deny it outright, or, most commonly, issue a stay-a-pause to allow the non-moving party time to take specific depositions or obtain necessary documents. The judge will not let a party win a summary judgment ambush simply by filing before the opponent had a fair chance to conduct discovery.
So the court protects the integrity of the fact-finding process.
Absolutely.
Now, does summary judgment have to be an all-or-nothing nuclear weapon? Does it have to kill the entire case? Or can the judge just slice off specific pieces of the lawsuit?
It is an incredibly precise scalpel when used correctly. Rule 56 allows for partial summary judgment.
Partial summary judgment. How does that work?
A judge can determine that certain material facts are genuinely disputed and must go to a jury, while other facts are completely undisputed and can be decided right now as a matter of law.
How does that actually play out in a courtroom?
The most classic example is splitting liability from damages.
Okay, let's go back to our car crash.
Oh, sure. During discovery, the plaintiff uncovers a dashcam video from a city bus that clearly shows the defendant texting on their phone, blowing through a solid red light and broadsiding the plaintiff's car.
Wow, great evidence.
And there is no counter evidence. So the defendant's liability, the question of who is at fault, is completely undisputed.
Okay, so the plaintiff files a motion for partial summary judgment on liability alone.
Exactly. And the judge will look at the video and grant it. The judge declares, as a matter of law, the defendant is 100% legally at fault for this crash. We are not going to waste a jury's time arguing about the red light.
But the case isn't over.
No, because the damages are heavily disputed. The plaintiff claims the crash caused a permanent spine injury requiring $1 million in future surgeries. The defendant has medical experts who say the plaintiff just has mild whiplash that will heal with physical therapy, and the damages should only be $10,000.
That is a massive, genuine dispute of material fact.
So the case still goes to a jury trial. But the trial is drastically shortened. The jury doesn't hear anything about traffic lights or texting. They are simply told, the defendant is legally at fault. Your only job is to listen to the doctors and decide exactly how much money the plaintiff is owed.
That is incredibly efficient.
It really streamlines the entire judicial system.
Okay, now I want to address a major procedural trap regarding appeals.
Oh, this is a big one for the bar exam.
Let's say I file a motion for summary judgment. I'm the defense lawyer, I think I have a slam dunk case, and I want it dismissed. But the trial judge disagrees. The judge says, motion denied, I see a factual dispute, we're going to trial next month.
Okay, motion denied.
Can I immediately run to the federal appellate court, bang on their door, and say, the trial judge made a terrible mistake. Look at my evidence. Overrule the trial judge and stop this trial from happening?
As a general rule, absolutely not. And this is a foundational concept for anyone studying federal jurisdiction. An order denying a motion for summary judgment is an interlocutory order. It is not subject to immediate appeal.
But wait, if the judge made a mistake and denied my motion, shouldn't I be able to appeal immediately to save my client the massive cost and stress of a pointless trial? Why make me suffer through the trial first?
Because of the final judgment rule, the federal appellate courts do not have the time or resources to micromanage trial judges in real time. If parties could appeal every time a judge denied a motion, lawsuits would take decades to resolve.
That's a good point.
The appellate courts generally only have jurisdiction to hear an appeal when a case is completely finished at the trial court level, when there is a final judgment that resolves all claims for all parties.
So a denial of summary judgment just means the case continues. It isn't over. The trial is going to happen.
Yes, you have to endure the trial. And then, if the jury rules against you and a final judgment is entered, then you can appeal the entire final judgment to the higher court.
But what if the trial judge agrees with me and grants full summary judgment, throwing the plaintiff's case out entirely?
That is the crucial distinction. A grant of full summary judgment ends the entire case. It leaves nothing left for the trial court to do. It is a final disposition on the merits. Because the case is officially over, the losing party is allowed to immediately appeal that decision to the appellate court.
So grant equals immediate appeal because the case is dead. Denial equals no immediate appeal because the case is still alive.
Exactly. That structural logic makes remembering the rule so much easier.
Okay, one final mechanical question on Rule 56. What happens if a lawyer is just, well, sloppy? They file a motion for summary judgment, but they forget to attach a key affidavit, or they fail to properly cite the record to support a fact. Does the judge automatically punish the client and grant summary judgment for the other side just to teach the lawyer a lesson?
Not necessarily. Rule 56E gives the trial judge significant discretion to manage sloppy briefing. The court is not required to play a rigid game of procedural gotcha.
That's a relief.
If a party fails to properly support an assertion of fact, the judge has options. The judge can give the sloppy party an opportunity to fix the mistake. Or the judge can consider the fact undisputed for the purposes of the motion. Or the judge can grant summary judgment if the rest of the record supports it. The goal is to reach a just result based on the true facts, not to hand out premature victories based on a typo or a missed attachment.
Okay, we have dissected the mechanics of Rule 56 thoroughly. Let's do a quick recap. Mini recap 3. Summary judgment standard. No genuine issue of material fact. The benefit of the doubt goes to the non-mover.
Yes.
The evidence must be admissible in content, even if the format isn't.
Right. The hearsay trap.
You can get partial summary judgment for just liability, and you generally cannot immediately appeal a denial of summary judgment, only a full grant.
Perfect. That covers all the MBE high notes for Rule 56.
Great. So let's transition our thinking to the final phase of our deep dive.
Okay, let's do it.
Everything we have talked about so far, plaintiffs quitting, defendants defaulting, summary judgments, all of these assume that a fight has already happened.
Right.
Someone was physically injured, a contract was broken, money was stolen, and now people are battling it out in court over who has to pay.
A traditional retroactive lawsuit.
Exactly. But what if there is no damage yet? What if two parties are looking at a messy, confusing contract and they genuinely don't know what it requires them to do? They just want to know what the contract means before someone accidentally breaks it and causes $10 million in damages. Can the federal court system help them figure it out? Or do they have to wait for the disaster to strike first?
They do not have to wait for the disaster. This brings us to a uniquely elegant and forward-looking part of federal law, the Declaratory Judgment Act. It's found at 28 U.S.C. Section 2201.
What exactly is a declaratory judgment? How does it differ from a normal lawsuit?
In a traditional lawsuit, the plaintiff is asking the court for a coercive remedy. They're saying, "Judge, make the defendant pay me money," or "Judge, issue an injunction forcing the defendant to stop doing something."
Right.
A declaratory judgment is entirely different. Under Section 2201, a federal court simply looks at a genuine legal dispute and declares what the rights, responsibilities, or legal obligations of the parties are.
Okay, so what's the key distinction?
The court does not award any damages, and it does not order anyone to do anything. It just establishes the legal truth of the situation.
It is essentially preventative medicine. You are asking a referee to clarify the rule book before you make a play that might get you penalized.
Exactly. The core purpose of the Declaratory Judgment Act is to resolve uncertainty and avoid massive, destructive future lawsuits. And the most common real-world application of this involves insurance companies.
Oh, I can imagine. Give us a scenario.
Imagine a chemical manufacturing plant burns to the ground. The factory owner files a massive claim with their insurance company, demanding a $50 million payout.
$50 million, okay.
The insurance company's lawyers read the complex commercial policy and they think, wait a minute, there is a specific exclusion in paragraph 9 that says we don't cover fires caused by spontaneous chemical combustion. We don't think we owe this money.
But if the insurance company just flatly refuses to pay the $50 million, they are taking a terrifying risk.
A huge risk.
Because if they are wrong about how to read paragraph 9, the factory owner won't just sue them for breach of contract. The factory owner will sue them for bad faith denial of an insurance claim, which in many states opens the door to massive punitive damages. That could cost the insurance company hundreds of millions of dollars. The insurance company is paralyzed by the risk of guessing wrong.
That paralysis is exactly what a declaratory judgment cures. Instead of waiting to get sued for bad faith, the insurance company proactively goes to the federal court and files a lawsuit for a declaratory judgment against the factory owner.
And what do they say to the judge?
They say, "Judge, here is the insurance policy. Here are the facts of the fire. We are not asking you to award us any money. We are just asking you to declare our legal obligation. Do we legally have to pay this claim under paragraph 9? Just tell us yes or no."
And if the judge reads the policy and says yes, the insurance company just writes the $50 million check, knowing they are legally obligated, and the matter is settled.
Right.
But if the judge says no, the policy excludes this fire.
Then the insurance company legally denies the claim, fully protected by a federal court order. The factory owner cannot sue them for bad faith because the insurance company was just following a judge's declaration of their rights.
It diffuses a highly volatile, massively expensive situation before the litigation explodes.
It does. And it's worth noting that while we are discussing the federal statute, most states have adopted similar uniform declaratory judgment acts for their state court systems.
That sounds incredibly useful for businesses trying to navigate complex regulations or contracts. But because we are dealing with federal law, there are always boundaries. Federal courts will not issue declaratory judgments for absolutely any dispute that walks through the door, right? There are strict statutory exceptions.
Yes, and these exceptions are highly testable on the MBE. The Declaratory Judgment Act explicitly prevents federal courts from awarding declaratory relief in actions concerning 4 specific areas of law. You must know these 4 boundaries.
Okay, let's list them.
Number 1, federal taxes. Number 2, certain bankruptcy proceedings. Number 3, free trade disputes. And number 4, drug patents.
Federal taxes, bankruptcy, free trade, and drug patents. Let's dig into the why behind these, starting with taxes. Why can't I ask a federal judge for a declaratory judgment about my complicated tax return before I send my check to the IRS?
It comes down to the existential survival of the federal government.
Oh, that's dramatic.
It really is. The government relies on the continuous, uninterrupted collection of tax revenue to function, to fund the military, to keep the lights on. If any citizen or massive corporation could pause their tax payments while they spent 3 years litigating a declaratory judgment about whether they actually owed the money, the IRS would grind to a complete halt.
The tax system would literally collapse under the weight of preemptive litigation.
Exactly. Therefore, federal policy mandates a pay first, litigate later approach. The Anti-Injunction Act and the tax exception in the Declaratory Judgment Act basically say you cannot use this tool to avoid paying taxes. Pay the IRS what they say you owe. If you think they're wrong, you can sue them later for a refund. It protects the revenue stream of the country.
That is a massive policy justification, and it makes that exception very easy to remember. What about the other 3? Bankruptcy, free trade, and drug patents.
The logic for those 3 is slightly different, but equally structural. Bankruptcy International free trade disputes and pharmaceutical patents are incredibly specialized, highly complex areas of law.
Right, they had their own courts.
Yes, Congress has created entirely separate, deeply specialized administrative courts and complex statutory frameworks to handle those specific disputes. Congress does not want general federal district court judges bypassing those specialized administrative procedures by issuing quick declaratory judgments. It preserves the authority of the specialized courts.
So pay your taxes first and let the specialized courts handle the drug patents.
Exactly.
That provides a fantastic conceptual map of how and why declaratory judgments operate.
It's a great system when used correctly.
Well, we have journeyed through the entire landscape of adjudication without trial today. We have looked at the strategic retreats of voluntary dismissals, the harsh penalties of involuntary dismissals, the procedural traps of defaults, the evidentiary battles of summary judgments, and the preventative medicine of declaratory judgments.
And breaking down the underlying logic of these mechanics is absolutely essential. The rules of civil procedure are not just an arbitrary list of deadlines. They are a highly engineered system designed to balance fairness with efficiency.
For everyone listening, especially those of you staring down a massive exam, remember that mastering the interactions between these rules is the key.
Absolutely.
Remember how the timeline shifts power from the plaintiff to the judge. Remember the strict difference between the clerk locking the doors with an entry of default and the judge handing over the money with a default judgment. Remember that summary judgment relies on genuine disputes of material facts, and that the court will not abandon common sense if video evidence contradicts a sworn lie. When you understand the engine, the individual parts make total sense.
And, as we conclude, I want to leave you with a broader perspective to consider as you continue your legal journey.
Okay.
In law school, and really in our culture, we spend an enormous amount of time revering the concept of the jury trial. We view it as the ultimate expression of democratic justice, the idea that our peers will listen to the evidence and decide our fate.
It's a foundational ideal.
But look at the true power of the pretrial rules we just dissected. Rule 41, involuntary dismissals. Rule 56, summary judgments. These procedural mechanisms grant an almost staggering amount of power to a single solitary federal judge. A single judge can look at years of complex litigation involving millions of dollars or life-altering injuries and unilaterally decide, no, a jury will never see this. I am ending this right now.
They act as the absolute ultimate gatekeepers to the courtroom.
Yes. So as you study these procedures, consider the balance. Do these pretrial rules make our legal system dangerously rigid, overly dependent on the mindset and potential biases of one individual judge? Or, realistically, given the explosive volume of litigation in this country, are rules like summary judgment the absolute only thing keeping our federal courts from completely collapsing under the crushing weight of frivolous lawsuits?
That reframes everything we've discussed today. It brings us right back to our opening thought. We all imagine the law as this grand, dramatic play on opening night, but the true power, the actual grinding machinery of American justice, it all happens backstage in rehearsals. The director is cutting scenes, actors are dropping out, and by the time opening night arrives, there's usually no one left to perform.
That's exactly right.
Thank you for joining us on this deep dive. Keep reviewing the timelines, keep exploring the logic behind the rules, and trust in your preparation. You have exactly what it takes to conquer this material. We will catch you next time.